So welcome, I'm here. I'm Robin Kelly. I'm interviewing Matin Papillon from the Université de Monréal. He's an associate professor there, very accomplished author, and director of Centre de recherche sur les politiques et développement social. And here we're just going to discuss a few things about your research and your opinions on a variety of topics. So to kick us off, in your perspective, how would legislation for free, prior, informed consent come about in Canadian law, and would impact benefit analysis or environmental assessment agreements be a possible first step?
Well, I think that free, prior, informed consent is really important, but it's also it's not a magic bullet. So one has to be careful how it's implemented, and how it's understood, right? So if free, prior, informed consent means that Indigenous people are invited to participate in a decision-making process that they ultimately don't control, because it's still the state that ultimately decides on whether a mining project or a hydro dam or a pipeline will happen, then it's not really consent. And currently in Canada, the different models that are being put forward to implement free, prior, informed consent are all models where the ultimate decision-making remains within state sovereignty. So it's not really about sharing authority. It's really much more about the state providing a mechanism for Indigenous people to participate in a decision, but not recognizing what is really the key for a lot of Indigenous people, which is their authority on the land and their authority to decide what's happening with the land that they are stewards of. So right now what we're seeing in Canada is that there's numerous proposals, but the language in these proposals, for example, in the Canadian in the new Canadian Impact Assessment Act that's debated in Senate right now, it's all about consulting in order to seek consent, but it's not about actually sharing the authority of deciding. So I think that's problematic. And so part of my research has been about trying to look at different ways that Indigenous people in Canada are engaging with the concept of free, prior, informed consent, but by giving it a different meaning, by giving it the meaning of asserting your authority on the land rather than participating in a state control process. And there's various examples of this that are quite interesting, I think.
Yeah, for sure. I guess it's the difference between consultation or consent. And we talked about that a little bit in the conference, I know. And along that lines, I know in some of your essays you said that veto power for Indigenous groups was sort of a preventative thing from getting it passed in legislation. But you also mentioned that non-consent is necessary for Indigenous groups to have in order to have a fair consent given. Could you elaborate more about how that works?
Yeah, well, the veto thing is it's interesting because when you talk to Indigenous people, leaders, and community activists, the idea of a veto is not really all that important. And it took me a while to understand why, because when you think of consent, you think, well, the obvious consequence of being able to consent or not is to have a veto on a decision, right? Like in sort of in medical process, for example, if you are consenting or not to a procedure, you're kind of vetoing what the other person is doing, right? So why is it not a veto then? I think it relates to the way you understand free, prior, informed consent. And so if you see it as participating in a process that you don't control, then it makes sense to talk of a veto, right? Because then you're vetoing the procedure of another party, for example, the state in authorizing a project. But if you're talking about free, prior, and consent as being an expression of authority, of controlling the decision-making process, then it's not really about vetoing something that other people are doing. It's about controlling this process, controlling the process itself, how the decision is made, and ultimately making the decision, which is not a veto. A veto is about saying yes or no to a decision that is made elsewhere, whereas I think for a lot of Indigenous people, consent means participating, or well, controlling the process or making it jointly with the state, depending on the case. But so the idea of veto is a bit foreign to the understanding of Indigenous people of consent in the context of Indigenous state relations, I think.
Yeah, so it's not sort of distancing themselves from the decision-making policies. It's more having an integrated impact within that legislative process. And I just had one more question for you here. In many of the negotiations between industries, governments, and Indigenous communities, you mentioned that the issue of power, there's an issue of power asymmetries. And you also mentioned that that was especially prevalent in impact benefit agreements. And I was wondering if there was room to address this within that context already, or if not, how so?
Mm-hmm. Yeah, that's another important point. I think impact and benefit agreements have become really hugely popular. Popular, I don't know if they're popular, but they're important in Canada and elsewhere. And the reason why is because in a sense, everyone likes them. The industry likes them because what it does is it buys in stability in a context of legal and political uncertainty where there's Indigenous opposition to a project. If you have an impact and benefit agreement, then what you're saying is, what you're negotiating is certainty, legal certainty on the project, because normally as part of impact and benefit agreements, Indigenous people will commit to not challenge the decision on the authorizing the project. So that creates a stable legal environment that industry need to fund their project, demanding the cost of the project right on the international financial market. So that's really important. And Indigenous people like impact and benefit agreements because this is a way to buy into the project and benefit from it and or minimize the impact. But the underlying assumption of IBAs is that the project is going to happen, right? Because you don't negotiate an impact and benefit agreement if you don't believe that the project is actually going to happen. It's not about whether the project will happen or not, it's about the conditions under which it will happen, which is different. And so are impact and benefit agreements good? Yes, if you agree with the project itself, but if you don't agree with the project, that's not a good way to go at it, right? So that's my concern. Now, the second part of your question was how to make this better, or is it possible to make impact and benefit agreement better? Because I just said there are good aspects to this. I don't think we should reject impact and benefit agreements altogether, because if a project is to happen, it's actually a good thing for the Indigenous community to have that kind of agreement. But it needs to be paired or coupled with something else, which is a process where Indigenous people can actually decide whether this project is good or not before negotiating an IBA, right? And also, one way to do this is to for the project proponent, the company, to commit to support an Indigenous-led impact assessment of the project, which is what I talked about in my conference today. The idea that, Indigenous communities themselves will do a review of the project under their own terms, taking into consideration their own perspective on environmental impact, but also impact on their rights, on their traditional use of the land, so on and so forth, and then come up with a decision. And if the impact and benefit agreement is conditional to that authorization, then it's not a bad process, right? Or, for example, another example which exists in some other modern treaty areas is if the approval of the project from the government, and now we're talking about government, is conditional on having an impact and benefit agreement negotiated. Then Indigenous people hold a veto on the decision, right? Because if they don't negotiate an IBA, then the project cannot be approved. So that's another way to integrate impact and benefit agreement better into the whole process.
Right. It's shifting around the balances of power,
Yep.
shifting around who
Exactly.
holds it and who has that.
Yep.
So that'd be an interesting way to integrate sort of the veto power and being close to the decision and being part of the decision-making process,
Exactly.
right? So thank you very much for talking to me today. It was lovely speaking to you, and I hope you have a great rest of the conference.
Thank you.
Bye.
You're welcome.